agnostics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Michael Baranowski, a professor of political science at Northern Kentucky University. I'm joined today by Cleveland area attorney and Republican factotum, Jay Carson. Hey, Jay.
Good morning, Mike.
How are you this morning?
I'm better than Earl Warren's ghost, who I believe is smiling down upon us
there you
this
go.
week.
We will explain in short order. That's good to hear. So before we do get going with that and all kinds of other stuff, I wanted to let folks know that I at least am trying out something a little bit different. I wanted to let you know about it. It's actually some video stuff. I've posted, I think at this point, 3 short videos, like 10 to 15 minutes on YouTube with my thoughts on various issues, like the Joe Biden Tara Reade thing, which Jay and I will be also discussing here, the armed protests in Michigan, and some more philosophical views on coronavirus, consumer spending, and capitalism. I'm against coronavirus and sort of for capitalism. Anyway,
kind of waffling on capitalism.
There you go, exactly. Yeah. It's still fairly rough. In fact, Jay, it reminds me of the first few episodes of the Politics Guys that we did, which you don't want to go back and listen to that. But I thought that if enough people find it worthwhile, I'll keep on putting them out, maybe 1 or 2 each week. So if you want to check it out, you'll find a link in the show notes for today. You could also, I guess, search for Michael Baranowski on YouTube, though I don't think I'm actually the top Michael Baranowski on YouTube, but you can change that, obviously. But anyway, you can find it. Let me know what you think. And if it's something worthwhile, I'm happy to do more of it. If nothing else, you can see what the shutdown, the lockdown has done to my to my grooming. It's not been pretty, that's for sure. So anyway,
I could do some of those too.
Yeah, maybe we can have Jay. You come on too.
Yeah,
as well.
It's rough, but like rough is
Yeah, so
there you go. Good. Like,
so go over there.
Like the Beatles at the Cavern Club, right? You know what I mean? It's that.
You've lost
edgy.
Me, man, but okay, there you go. So see, I'm not a Beatles guy even a little bit. So I've always been much more of a Stones guy. But anyway, another conversation. Once again, we are ad-free this week because, well, honestly, ad spots have essentially dried up in this environment. And it's not just that advertisers are being more cautious. It's also that podcast listening appears to be taking a general dip, which I guess because, Jay, people aren't commuting as much. So there you go. But, and that's why we are particularly appreciative of the people who've either become new supporters of the show, like this last week, Adam and Heather. Thank you guys very much. As well as current supporters who've been able to increase their support. And of course, if you are a supporter, you get access to a full-length bonus show each week, as well as other stuff at different levels. And to check it all out, just go to patreon.com/politicsguys. And if a monthly support pledge is too much of a commitment, there's also PayPal. You'll find a support link at politicsguys.com/support. And we always, of course, include those links in our show notes. And finally, if you would like our bonus content, but you can't afford to financially support the show right now, totally not a problem. Just email me at mike@politicsguys.com, and I will make sure that you get access to everything we're putting out. Okay, Jay, so what do we have to start us off with this week?
Well, our first story, and this fits into my Earl Warren quip, if for those who didn't get it, but is the Justice Department's decision to drop its case against former Trump National Security Advisor Michael Flynn. As folks will remember, Flynn had pled guilty and been convicted of lying to FBI investigators during a White House interview early in his tenure, which was all of about 2 weeks. And then, however, after a new exculpatory information was released, Flynn sought to withdraw the plea and dismiss the claims against him. Some of this exculpatory information indicated that the FBI had originally looked at closing the investigation of Flynn, the counterintelligence investigation, which related to Russian collusion, but were persuaded to hold off on that decision by Peter Strzok, awaiting instructions from the 7th floor. FBI internal memos also indicated some FBI skeptics said it looks like this was simply a set up to a perjury trap, or maybe to get Flynn fired. The Justice Department, in dismissing the case, said that the the prosecution was untethered to and unjustified by the FBI's counterintelligence investigation into Mr. Flynn, and that the interview was apparently not conducted with a legitimate investigatory basis. So, with that, Mike, I think this is, this is something that you and I have held off on talking about a lot of times because our rule, and I think it's a good one, is that we don't jump into speculation, conspiracy theory, that sort of thing. We wait until there's some actual fact or document or decision or something to anchor our discussion to. And in this case, there is first the decision by the Justice Department and the filing by Flynn's attorneys of all this exculpatory material that is now out there. And I got to tell you, I think we owe a tip of the hat to our longtime listener, frequent correspondent, and your sometime antagonist, Scott, on this. This, to my view, this is a very bad look for the FBI and would appear to have been a violation of General Flynn's rights. But I want to hear what your thoughts are.
Well, this gets into another story as well, but I got to say I love how Jonah Goldberg, who of course is a longtime favorite of both of us, he used to be a columnist for the National Review. He moved over to his new thing called The Dispatch, but in his column this week, I don't know if you had a chance to see it yet, but he writes, "So the economy is cratering. The White House seems precariously close to simply pretending the pandemic is over. Big chunks of the populist right have decided that the new front line of liberty is refusing to wear face masks and requiring that everyone genuflect at the altar of Michael Flynn. Meanwhile, big chunks of the left are untroubled by the antics of an FBI that managed to turn an admitted foreign agent of the Turks, not the Russians, into a martyr." And I thought, once again, I think Jonah Goldberg, fairly nailed it there. It made me think, in first part, kind of pulling back about framing. And framing is a term sometimes used in political science and communications, not the common context, which some people would say Michael Flynn was framed, but right. But
well, I think it works in that context too.
Well, we'll get into that, but it refers to the frame, or the way I look at it. Maybe it's more intuitively understandable this way: the lens through which we view things. Though you can understand why they used framing, because lensing just sounds like some kind of weird sex practice or something. I don't know. But anyway, but it's basically a way of simplifying the world, kind of a heuristic mental shortcut, that sort of thing. And it seems to me, in thinking about the whole Flynn, Trump, Russia investigation thing, there are two predominant lenses. And the first one, and my longtime antagonist, supporter, listener, whatever of the show, Scott, this would be, I think his, it's hoax, fake news, right? The failing mainstream media and their allies in the deep administrative state. Well, they're going to stop at nothing in their, what's going to be ultimately doomed attempt to destroy Donald Trump, who is, of course, the people's president and, supporter of all that's good and American. And so that's the frame we hear a lot on the right.
Then I'll just interject that there is now some evidence to support that view.
Okay.
But go ahead.
And then the frame on the left, right? The Trump administration, it's utterly corrupt because, hey, Donald Trump, he's an ignorant, amoral, narcissistic monster. And everything they do is just, complete and utter garbage. And so you got this guy and his craven minions, like, for instance, Attorney General Barr. Well, they're going to stop at nothing because they don't care how much hatred and discord they sow, because they need to rally that ever kind of dwindling number of bitter racist clingers who brought him to power. And so it seems to me those are the two frames through which everyone, or not everyone, a lot of people are looking at this. And I think there's a certain amount of truth to both of them, but I also think that they're both sort of straw men. They're very oversimplified. So
sure. No, I'd agree with you on that.
I tried to step out of my frame here a little bit. And obviously my frame is going to be much more, number two than number one. And so it seems to me that, that you mentioned like a perjury trap, right? And it seems to me that I bet if somebody with the resources and the connections of a Michael Flynn were able to look into pretty much any random number of FBI, high-profile FBI investigations, or just law enforcement investigations, they would find a lot of shady stuff. Not necessarily illegal stuff, but stuff that went right up to that line and maybe danced a foot slightly over it. And that's not, I don't think, necessarily because there's a deep state conspiracy to destroy Donald Trump. I think it's a much more likely explanation is, wow, this is a super high profile case and this can look really good for me. And so we're going to do everything we can within reason, within the law, even if it's a little iffy. Like, for instance, saying that, well, we don't know exactly how much Michael Flynn knows, but we need some leverage on him. And hey, let's push a little bit and let's see if we can trap him in something that's maybe only tangentially related so we can get him to, say what he knows. And it seems to me that that's not terrifically surprising. And that's something that I expect happens all the time. The difference is that most people don't have the ear of the president and don't have friends very high up in the Justice Department, as in the very top. And so that sort of stuff just is a matter of course. So that's my sort of larger frame on that. And I wanted to get your reaction to that first.
Well, first, I'd say there's one. I think you're correct in that the Justice Department, I think, would do some things that we may find troublesome. May find dishonest. I mean, it's the cops are allowed to lie to criminals, right? I mean, that's one of the rules. That said, I think the other piece that you need to look at, and I'm sorry, I blanked for a second there, is that setting perjury traps has to do with, is there actually an investigation to be had against this person or against someone else? And what this evidence tended to show was, one, the FBI knew in late 2016 that Flynn was not involved, or at least they had not found any evidence of any sort of collusion or improper contacts. The basis of this interview was set up on maybe there's a violation of the Logan Act, which, as we've talked about, is sort of a historical chestnut from 1799 that no one's ever been prosecuted under, is probably unconstitutional. And the FBI itself realized it really had no case for a Logan Act prosecution. So that setting that aside, the other thing I want to push back a little bit on is you're saying that, well, Flynn has these resources, extraordinary resources, but in this case, the information that he received and was able to get is information that should have been turned over as part of discovery in any criminal investigation. It's exculpatory information, and the prosecution is required to turn this over to the defense. Now, there is some, we'll have to talk about that later, about whether they did or whether they didn't and what happened to it. But this is not something of any criminal defendant would have access to this same type of information, or should have access to this same type of information, because it is a basic procedural safeguard. So, okay, I'm sorry. Now go ahead. So we have the two lenses, and I'm just responding to that.
Yeah, well, I wonder about that because Flynn's, if I understand Flynn's defense, he initially hired one of the premier law firms in Washington, D.C. or the country. And his initial argument was, well, they were not very good, actually. And so he hired these other folks. And so I got to wonder if just some regular normal person, who's caught up in something. So I guess I would argue that while there may be all of these protections in theory, in practice, for regular people, this isn't necessarily the case. And it mattered a lot that Michael Flynn was who he was and knew who he knew. And that's not just a Donald Trump, Michael Flynn thing. That could be true whether your name's Michael Flynn or Jeffrey Epstein or a whole bunch of other people, I think.
Yeah, I think the evidence will show, and there is an order that Judge Sullivan has put on there for Flynn's former counsel to respond to the court. And I think it's going to reflect that his former counsel did not serve him well. And there'll be more to come on that, I think.
Okay. All right.
But but I think that's I would say in most cases, the again, when you're thinking, someone who's a target of an FBI investigation, white collar type FBI, these materials are available. They are typically turned over. It's not a matter of picking up some kid on drug possession. Yes,
Yeah.
obviously they don't have the same type of resources, but also it's not the same type of exculpatory material that's out there that needs to be turned over. But go ahead.
Also, I want to say that it seems to me that it's easy to conflate two things. There's the issue of whether or not this was a legitimate investigation, or whether Flynn was a legitimate target in this investigation. Then there's the bigger question whether the investigation itself was legitimate, which we're not dealing with. I think Attorney General Barr certainly has his views on that differ than mine, but there's the secondary issue of whether or not Flynn actually lied about what he did, and people are tending to put those two together. I think even the Attorney General suggested that there's not really enough information to determine whether or not Flynn lied, and that seems to me to be a separate issue and a kind of a bizarre claim, because Flynn admitted this twice. The president said that, I had to fire General Flynn because he lied to the vice president and the FBI. Mm-hmm. There's corroboration of his actually telling untruths. And so, that's a whole other issue, but it seems pretty, at least I haven't heard any clear contravening evidence that Flynn lied to the FBI about his involvement, about his conversations with the Russian ambassador before Donald Trump took office. Now, whether or not that the investigation was legitimate is another story, but I think it's important not to conflate those two things. And as Jonah Goldberg said, that's why I liked his comment saying that this is it seems to me to be a guy who maybe did some pretty shady stuff. That's not to say that what the FBI did is right, because it doesn't seem to me to be certainly entirely above board, but that doesn't exonerate Michael Flynn, say, he's an American hero. He seems to me to be a pretty scuzzy guy, actually. But hey, the FBI maybe didn't do the right thing by him. So that's what I mean about these two frames. It's just basically saying, Michael Flynn's associated with Trump, and if you believe in that kind of first frame, then Michael Flynn is an American hero, and so that's fine. This is total exoneration, which just seems insane to me.
Well, let me propose a third frame.
Okay.
And that is Michael Flynn is not an American hero necessarily, although he did serve honorably in our armed forces as a general and did all kinds of stuff like that. But rather, he still is an American citizen.
Yeah, absolutely.
And as such, quite honestly, if he's scuzzy, if he has bad character, if he has bad motives, even if he breaks the law, that's immaterial to the question of, did the government overreach and violate his civil rights?
Yep, I totally agree.
And to me, that's the bigger case. I mean, the whole point of these civil rights that we have is that they apply to people who we don't like. They apply to scuzzy people. Everyone would be happy to give the benefit of the doubt or the presumption of innocence to people they like. It is these others. It's sort of the First Amendment type argument that First Amendment obviously protects offensive speech because inoffensive speech doesn't require any protection. So that to me is the bigger issue, and I'm much more concerned about government overreach, especially government overreach on a political basis, than I am about Michael Flynn being scuzzy, so to speak.
Yeah, I completely agree. I mean, I think people sometimes underestimate the enormous power and resources of the state, because if the state or if the law enforcement at writ large decides they're going to make it their mission to get you, look out.
Right.
I mean, that's huge. That's daunting, no matter who you are. And
yeah, and I'm sorry to interrupt.
No.
Yeah, to my Earl Warren point, a whole lot of these cases. I mean, Miranda was kind of scuzzy.
Yeah.
MAP was kind of scuzzy. I could give you a whole list of all these cases where the defendant was not necessarily someone that of high character, but that doesn't mean that they don't have civil rights. And to me, this is a much bigger deal because this is a prosecution that is political and certainly appears to be motivated by an effort to get Donald Trump. And there's more that's going to come out about that. One more thing I want to push back a little bit on is the lying or not lying. According to these documents that were released, and again, this is why it's exculpatory material, is the agents who interviewed him did not believe he was lying. At least not intentionally so, that it may well have been some sort of, look, you're doing a whole lot of things and you may not remember everyone you speak to. But that report was then rewritten several months later by Andrew McCabe to reflect something different. And that's what's really troubling. It's also a matter of there may have been misrepresentations to the court. The lead prosecutor has withdrawn, and I think there's going to be some questions on that follow. Just as there were misrepresentations to the FISA court, and look, you've got a couple examples here where we have absolute documented evidence that the FBI was not just playing hardball, but was violating rules of accepted rules of constitutional violating constitutional protections. So that to me, I mean, it's look, whether Michael Flynn's a good guy or not is immaterial. It is when we have a government that is using the criminal justice system to pursue political aims, that's intensely problematic. And
so we actually don't agree on this at all. It seems to me, based on what I have seen to this point, that my inclination is to agree that it was right to dismiss the case, the charges against Michael Flynn. And that's difficult for me to say because, of course, that requires me to step out of my preferred frame on this. But again, on the other side, that's why it's important to say that doesn't mean necessarily that just because the investigation has been botched or political or what have you, that doesn't necessarily mean that there's nothing to investigate. That there are two separate things that people. So what I'm saying is that just because the FBI overreached, and it seems to me that that's a reasonable conclusion to reach, doesn't mean that there's nothing, that the whole thing is a hoax.
Okay. Well,
they're two separate things, is what I'm saying.
I understand. That's a. I think you can, just because Miranda wasn't read his rights doesn't mean that he didn't do it.
Exactly. And so I guess that's what I'm asking. That's what I feel like people need on both sides need to make more of an attempt to. Because, of course, on the left, what we're saying is, well, Attorney General Barr is totally in the bag for Donald Trump, and he is just doing all this stuff, making these decisions. And Barr is, conveniently saying, well, this is just what the law says and so forth. And so the the claims are on both sides. And this is sort of inherent when you have any high level political investigation. And this gets to a larger point that I've been arguing for a little while now. To me, it's yet another reason why we need an independent Justice Department. I mean, the only independent thing we had is the Justice Department's Inspector General, and they found there was sufficient cause to investigate Flynn. But I don't know if the IG had access to all of these documents and so forth. That's, I think, still not quite determined, but
exactly.
But to me, it's I think a much better system, especially in these times of what seems like permanent polarization, is if the Attorney General, like again is the case in I believe 45 out of 50 states, is elected directly by the people, not appointed by and serving at the pleasure of the president. So you don't have things like Donald Trump saying, well, if William Barr had been Attorney General, there never would have been a Russia probe. He would have stopped it immediately. So, that's not a good thing to say, obviously.
No, and it's not. But
my point, my larger point here is that, and not only that, and this is maybe even more important, is that the president also appoints and can dismiss all 93 of the U.S. attorneys, and they're the ones who do most of the legwork on this sort of thing. And so, to me, a much better system would be where there's an independently elected attorney general who appoints the U.S. attorneys subject to not just Senate approval, but congressional approval, because that's another thing. I think there's no good reason why the Senate should be the sole confirmer of anyone, actually. And I think that requiring both chambers to confirm nominees would almost certainly mean fewer extremists. And I think that would be a good thing both on the left and on the right. And so this is another instance where I think that we have a system that was set up in a different time under different, just under a different time, believe it at that, and it's not serving us very well now. And I think this is a case where the states are more right. Go ahead.
Let me ask, why isn't it serving us very well now? I mean, if we've established, and you seem to admit it, justice overreached on this. This was not a prosecution that should have happened. They appear to have violated their own rules in doing so. They have appeared to have violated the Constitution in withholding exculpatory information. Why? I guess the sense is, well, would this have been better if you had a partisan elected Justice Department? I think that's absolutely awful.
Well, I think this is not. We do have a partisan Justice Department, is the argument, and that it's just not openly.
The state attorney generals are elected on a partisan basis.
Absolutely, and I think that's much more transparent in that sense, and there's much more direct accountability, and also much more independence. And so I think the idea that and so I think that's just a much better system in that, and this is not an isolated thing. There are plenty of things that we on the left feel that Attorney General Barr has done that are, to say the least, suspect. And what this is, this isn't the time or place to get into a laundry list. I don't have one, but I could come up with one certainly. But that's the problem, is both sides seem to have lost faith in the legitimacy of this system. And I think in part it's because both sides see it as being tethered to this, to this blatant partisanship. And I think it just makes more sense as a matter of practice, as a matter of structure, to separate out the people who are making these decisions on prosecutions from the administration. Because right now we have a situation where the administration basically gets to choose its own prosecutors in a way, even when the target is itself.
It's almost like, if someone could they could appoint their own brother as attorney general.
Exactly. So you're saying, well, there's this ridiculous case. So
the press would go nuts.
Yeah. Well, and that's the point, right? And so I think
that person would be barred from ever pursuing office. And
you're making it. You're saying this facetiously, but I think it's an important point, in that it's important to have the legitimacy and the public trust in this sort of thing. And I think anyone recoils at the idea that they would be able to appoint their own prosecutors, because that just seems on the face of it to be wrong. So maybe we don't need a fully independent Justice Department, but clearly the system we have for political investigations is not working out very well. And I don't think that anyone would disagree with that.
You could go back to the independent counsel model, and that seemed to work even less well.
Yeah, I don't know. Yeah, I don't know that.
Let me just jump in here, because there's a couple of things that I think need to be said. And look, everybody has their frames, but at this point, we have evidence, we have documents.
Yeah, I'm not disputing that. Yeah,
that one, again, they said, look, we've cleared Michael Flynn from any alleged collusion. There are things that looks like it's we're trying to do.
Just to be clear, they haven't cleared him of any collusion. They did not find evidence. Isn't there a difference between clearing somebody and not finding evidence of?
Well, yeah. I mean, here's the thing. When you have all these resources, and I thought about this analogy for a long time. This goes not just to the Flynn thing, but the larger thing. Suppose I say I believe in Bigfoot. I think Bigfoot is out there. That's sort of a big claim, right? And we have a task force, and say we have a report saying, "Hey, I saw Bigfoot. I've got a photograph. We need all the federal resources we have out there, and you spend all of the money you have. You have a inspector general, all the wiretaps, secret wiretaps, all phones, satellites, all this stuff, and you're going to do a full press search for Bigfoot. Not only that, but you hire people who are true Bigfoot believers. They really, really, really want to find Bigfoot, and you spend years searching the Northwest. And still no Bigfoot. At some point, you have to say, look, he's just not out there, and maybe that doesn't mean he's not possible, still out there, just hasn't been found.
Yeah.
But once you've spent all that energy, all those resources, and of the massive federal government, and come up with nothing, then there's sort of a presumption.
Yeah. Okay. Now, and more often. Well, let me before you get past that,
because this is a really good analogy.
Well, wait, I do want to. Yeah, I want to build on your analogy. So let me just stop you just for a second, because it seems to me you've gone past Flynn here, and that's okay. But I would add to that analogy that you have these Bigfoot people and all that, and actually that they found suspicious droppings that looked like Bigfoot droppings, and this would be the Mueller report, but also there were areas of the forest they couldn't go to. They didn't have access to. They were shut off to them. Oh, absolutely. The Trump administration many officials would not cooperate. There was documents that weren't allowed to be,
Can you blame them at this point?
Well, no, but I'm saying if you want to,
I mean, look,
I'm saying if you want to extend that analogy, you want it to be a fair analogy, Jay.
On over.
I mean, if you want it to be a fair analogy, you have to extend it into that. So like all analogies, it simplifies, and I would argue that it oversimplifies in this case. And that gets back to the frame. I mean, it seems to me that I am willing to step outside of my frame and say, it's entirely possible. And I think this is a reasonable thing to say, is that there's been a lot of overzealous and even illegal things that have been done by the law enforcement community, the federal law enforcement community, in pursuit of this case of Trump-Russia collusion, right? I think I think a reasonable person can absolutely come to that. And there are some things that just seem incontrovertible, like documents that have been altered and stuff like that, that's just flat out just wrong, illegal sort of thing. I think that's absolutely the case. But
yes, it turns out the picture we had of Bigfoot was actually a guy in a suit.
But see,
and you know what? This is the other smoking gun type document, is they knew that before they launched the larger investigation.
See, and that's where I guess I feel like I am, trying to step a little bit outside of my frame here. And it seems to me like you're saying that, well, not guilty means completely innocent, and that I'm wondering.
Yes.
I'm wondering. Well, I mean, to what extent?
Our justice system is not there to determine innocence. It's to determine guilty or not guilty. Sure.
And that's an important distinction.
With you. And Flynn may be the devil, and he may be the greatest Russian mole ever. And Bigfoot may be sitting up on top of the mountain laughing his ass off that these guys can't find him. But at this point, that's our system. That's what we've got. Okay. And our justice system isn't there to pronounce a final judgment on good, evil, moral, immoral. It's was a law broken or was not? And I think in this case, justice overreached and violated the civil rights. There will be more to come, and I think Mr. Flynn will be a very wealthy man after all of this.
Yeah, and on Flynn, I think in the end, I agree with you very substantially on that. On the larger investigation, I think there are other issues and things. And one thing, we're still waiting on, and this has gotten completely lost in obviously what's been going on with coronavirus. We're still waiting on the Durham report. Yeah, and that was obviously supposed to come out before now, but I'm sure it's been delayed. You really don't find much of anything about it yet, but I still imagine that will come out maybe sometime this summer. And that I think is going to be very important. I will be extremely interested in learning what that finds, because the U.S. attorney who was appointed to do that has a sterling reputation for being fair-minded, been under Republican and Democratic administrations, and I think that the extent to which people on both sides will be willing to accept some of those findings will tell us a lot about the extent to which people are comfortable with stepping outside of their frames.
Okay. And I will make this commitment right now. I will accept Mr. Durham's findings to the extent that they comport with the evidence, which I expect that they will. And I also make this prediction that when his report comes out, he will be trashed as a partisan hack.
Oh yeah, I definitely.
You heard it here first.
That's going to happen by either side, no matter what. Yeah, there's no question he's going to be trashed.
No, he will be trashed as a partisan hack by the left. But
so you assume you assume what his report's going to be in advance of the report.
Based on, at this point, there is a lot of evidence out there that I've now seen, that people have now seen, that show that the FBI was acting improperly, both in the FISA thing and in the Flynn thing, and not just improperly. I mean, this is, altering documents to send to the court to seek secret surveillance on American citizens.
Yeah.
Wow.
No, and actually, I agree with you on that, because given what the purview of his investigation is, and that's investigating the investigators, I agree with you. Actually, I find it extremely difficult to believe that he's not going to find even more than I.G. Horowitz found, because his scope is
Exactly,
considerably broader. So yeah, I think you're absolutely right about that. But we will see the extent to which that. But yeah, I think you're substantially right about that. And I got to say that the more that I hear and read about official documents that come out about this, the more I think that anyone on either side who cares about civil liberties and an honest, transparent system of justice should be just appalled at this. Yeah. And
there you go. That's what I'm talking about.
I think the stuff that Director Wray is saying he's doing with the FBI isn't going to be close to enough, saying, oh yeah, we'll take care of that. I think we need a 21st century version of the Church Commission, which investigated the CIA just being totally rogue in the 1970s and before. And we need to really just fundamentally rebuild.
I would support you on that.
So yeah,
we are together, united on that front.
There you go. And I would say that whoever is reelected president after we're behind, after the coronavirus thing is, please God, behind us, that should be a top priority, making that, a thorough investigation into this, and some, not just, and some serious reforms, because we've got problems.
Absolutely.
All right.
So speaking, I'm moving on, and a little sort of that same vein, in keeping with our Bill of Rights sort of show this week. Secretary of Education Betsy DeVos recently approved the final rules relating to investigations by schools of sexual harassment and sexual assault. These had been in draft form for some time, so it was not really a surprise, but these are the final rules that will take place April 14th. And what they do is they reverse Obama-era rules regarding due process that is permitted in these investigations. For example, the rules will allow the accuser and the accused to submit evidence. They participate in live proceedings, including cross-examination. Also, they will be able to appeal a ruling of a school. Schools will be required to state the standard that they're using, whether it is a clear and convincing standard or preponderance of the evidence standard. The Obama rules had said preponderance. This does not require the clear and convincing standard, but does set forth sort of that you have to tell everybody up front what the standard of proof is. So with that, I mean, my sense is, again, as a civil libertarian, and that you would probably be okay with this. There's been pushback from victims' rights, victims' advocacy groups on this, but my view is that this is or ought to be viewed as sort of non-exceptional. This is just sort of standard due process for someone, and I think it's a good return to normalcy. But Want to hear your thoughts.
Well, first off, I want to get a little technical because the Obama administration didn't actually issue rules on this. They issued what's called a guidance. And,
Yes,
and guidance, there's an important distinction between guidance and regulation. Just briefly, guidance is an agency's interpretation of the rules, but it's not a legal requirement that something be done, which a regulation is.
Right.
Also, guidance doesn't go through the regulatory approval process. It's not subject to the Administrative Procedures Act because it's not an actual rule. And also, guidance can be altered and withdrawn at any time where regulations can't. In fact, Betsy DeVos withdrew the Obama administration guidance in 2017, and we've just been waiting for this rules. And so I think absolutely we needed rules more than guidance because the guidance of the Obama administration was kind of hazy and it wasn't clear. It left things kind of amorphous. I also think it's important to have a clear and uniform standard of proof. And as you mentioned, actually what universities and institutions are able to do now under these new rules is they can choose between either preponderance of the evidence or the higher bar, which is clear and convincing evidence, but they can't use the lower standard for student issues if they're using a higher one for allegations against employees or faculty members. So it has to be consistent across the institution. So I agree with you that that more clarity was definitely needed for. And I think it's fundamentally important to have someone accused of something like sexual misconduct to have the right to a hearing, a live hearing, and the ability to cross-examine accusers. Now, in cases like this, I also appreciate that there are issues with accusers not wanting to or having difficulties facing someone who may have assaulted them sexually, certainly. And that's why I appreciate that under this system that there were protections and shields, no direct contact between the accuser and the accused. And
sure, yeah, you can have no contact orders, all that sort of thing.
And there are still rape shield protections, sexual history can't come into play, that sort of thing. And so overall, I think it's not necessarily such a bad thing because we needed something a little clearer on this. And I'm coming from a standpoint of somebody who works as a higher ed institution and has seen a number of these things play out. In certain institutions, basically you can just have one person, one like Title IX person who can be the investigator and the judger of these complaints, which that seems like a pretty bad idea to me. Now, and so, yeah, on the due process issue, I tend to agree with you. Now, of course, Jay, as you know, that somebody can, this is like within the institution sort of thing, and somebody who is alleging an assault can pursue criminal and civil type of things, and those would be separate. And then
sure,
those are different. Those due process rights have always been in place. This is only in the context of administrative proceedings within an educational institution which receives federal funds, which is basically everybody. Every higher education.
Well, but that's sort of the point was to bring these internal administrative proceedings into line with the due process that you would receive in a civil or criminal.
Now, of course, one conservative argument might be, well, why should the federal government get involved with these businesses and let them? Why don't they just let them have their own internal procedures? What are they going to get involved with my HR department next and set their due process sort of thing? So I would think you could say that a conservative argument would be that these institutions are best positioned to decide their own internal operating procedures, and if somebody wants to, take issue, has a claim, well, they can file a civil or a criminal claim, and these institutions should have the freedom, should have the liberty to do what they want within their own boundaries. And I kind of want to get your take on that.
So I would push back on that. Look, the issue has not been look, to the extent that colleges and universities have been able to decide this on their own, they have decided it in one way. They have decided it uniformly. And that is the victim is to be believed. The accuser is not able to present evidence. But
I'm saying, why does that matter? I guess what I'm saying is, for instance,
well, because civil rights, because it's fundamentally unfair. And if you are asking the government to pay you money, right, and this is government funded institutions, and they are using that money, at least in part, to conduct processes which are fundamentally unfair and ought to be offensive to our sense of justice, well, that's not something that the government ought to do. So it's perfectly appropriate for the government to say, listen, if you're going to have these kind of processes, they have to comport with basic fundamental fairness.
Yeah.
Just as if you're going to receive federal funding, you can't discriminate by race or sex or religion. These are important values to us, and you ought not to be able to violate that
Sure.
willy-nilly.
Yeah.
So, I mean,
Now,
I think that's the argument.
yeah, absolutely.
For
I just wanted you to. I mean, I got
that one right, didn't I?
Yeah, I don't disagree with that. I thought you would be better positioned to sort of explicate that than I would. So that's why I wanted to ask you. So, do you think that logic should be extended, say, to businesses that get small business association, SBA loans and bailout stuff, that sort of thing? I mean, that would just be an extension of that logic, right? Or is it
to some extent it is, right? I mean, some of these programs do come with strings attached.
Mm-hmm.
Small business loans are a little bit different, but again, it's a weird sort of the college situation is. These are life altering things that go on people's permanent record, right? It's one thing to be let go from a company. It's quite another to say you were a sexual offender and to be branded with that for the rest of your life. So I think.
Well, it seems to me it would be the same sort of claim, whether it's at, say, your law firm or my university. If there's a record that you are you are a sexual offender, then there's a record of that, and so that's why I guess.
But again, there would also be a civil process that you would have access to,
right? And as you would with if you're a college student who's alleging something like that. Yeah, no, that's not that's a.
So who do you? I mean, no, I guess this is the thing. Of who do you sue? You sue the college saying that you violated my civil rights. The college, absent this rule, I think they might say, well, look, no, we had a process. Now, some of these cases have already are gone to court, and I expect that this kind of moots a lot of them. But one, you're talking about college kids. Secondly,
but adults. I mean, so are we going to make distinctions now between young adults and older adults, or? And I guess what I'm asking here, and you see what I mean, I'm pushing you on this, not because I don't think you and I fundamentally disagree here, but from a, say, more staunchly libertarian viewpoint, say, I can see somebody saying, you know what, this is a value that I think is very important, but I also think a value that's important is allowing institutions to set up their own rules and not to have the coercive fiscal power of the federal government to ram a procedure down their throat.
Yeah, but here's the thing. I think that you're missing. You talk about businesses and so forth. There already are these laws in place if you're a business, right? In terms of sexual harassment, in terms of so all these things. It's not like they can be, those. What I'm saying is the business community is already regulated, right?
Sure, but I guess I don't understand.
I mean, you follow me? I mean, I guess if someone, and there are already remedies in the business community, and in colleges there aren't. There's also sort of the timing issue of look, if you are thrown out of school and you've got to get back into school, you can't take just a couple years off pursuing your lawsuit. I think. I guess I'm not sure what exactly you're arguing for, other than to say we should have these types of due process requirements for businesses, but I'm saying they're already out there.
Well, it seems to me that there may be a bit more, not a bit more, but a lot more extensive for educational institutions. The new regulation here is over 2,000 pages. So there's that. But I guess more
Well,
generally,
ever heard of the EEOC? I mean, that's
yeah,
a
that's
whole
true.
agency devoted
That's true.
to
Yeah, good
this.
point.
I mean,
Good
this is
point.
there's a big whole, you know,
So, but
government.
you feel that there are reasons maybe that education is special and different and should be maybe singled out or treated differently is what you're saying.
No, actually, I'm arguing that education should be treated the same, and that's sort of what these rules are saying.
Okay. I don't know that I disagree. I don't know
What,
that I
what
agree
I'm
with
saying
that.
is you, if
Like for instance, let me bring it to you this way.
okay.
Maybe I'm wrong about this, and you'd be in a better position to tell me certainly. But I don't know that there are requirements for internally, say in a private non-educational business of administratively dealing with the claim of sexual harassment that any institution has to choose between these two standards, and it has to be consistent for this, and they have to have a live hearing and ability to cross-examine accusers. I certainly wasn't aware that all of those things were federal requirements on private businesses that weren't educational.
Yes. I mean,
All of
yes,
those things.
if you accuse, I mean, if you are, if you're in a business and you think someone has sexually harassed you, you have access to federal civil rights laws. You can sue them.
But isn't that different?
They
I guess
they can't. No,
okay.
no. And then that business then has the right in court to defend itself, and it has cross examination and get evidence and do all
Right.
that. So likewise, if a business then were to fire you for an allegation of sexual harassment, maybe that's the better
Yes,
model.
exactly. That's
that
what I'm
you're
talking about. Yeah, exactly.
You would, depending on your contract, but certainly if it's disclosed, you would have, and if it was false, you would have a defamation claim that again could be brought in court and would be pursued. Both everybody gets to testify, and you get to put in evidence, and you have a plain burden of what everybody has to prove. So that is the same as what we've got here. I think that's if we have at will employment. But again, I think if someone is just, now look, I suppose if you want to say they're fired because there was an allegation, businesses just didn't want to have the hassle. Okay. The person doesn't want to bring the suit. Okay. That's fine. But I think that's a different animal than colleges where you are labeled a sexual harasser. Because I think if you were, this was made public, again, you'd have that defamation remedy.
Yeah. See, I guess we're kind of at a point of diminishing returns here, but I think what the crux of our disagreement is that I feel that institutions shouldn't be, the federal government shouldn't be determining their internal administrative operations, using their massive fiscal power to ram that down their throats. And if people have an issue with that, they still have civil and criminal remedies, just like they do in the private sector. But
let's put it. Okay, then let's say there's a school that says, you know what, we're in a big financial crunch. Women's sports bring in absolutely nothing to us monetarily. We need to cut them and focus all on men's football.
Yeah, and there's a specific law against that, as opposed to an administrative guidance.
Right, but isn't that the federal government reaching into the private decisions of a college or university?
Yeah, absolutely it is. Absolutely it is. No question.
And you're okay with that, so I would think you'd be okay with the other. I mean,
well,
they're actually both coming out of the same title, right?
Well, this is something that you and I have both talked about, I think, in a number of other contexts. Is I'm a lot more okay with laws that are passed by Congress than with administrative guidances or regulations that are promulgated by the executive branch. And so that's why I would separate those things. Now, if Congress came back...
regulations like this, at least you have that Administrative Procedures Act process where there is some sort of public comment, due process, deliberation, as opposed to guidance, which is just...
Absolutely. And that's why I prefer this to guidance. Yeah. And so I guess, and on that issue, it's kind of interesting because a lot of the institutions are saying, we disagree with this, obviously, because they don't want to be told what to do. They like their processes, but more than that, they're saying it should.
That's the reason?
Well, yeah, that's a big part of it. I mean, absolutely. They feel that their processes are superior to what the federal government is mandating here. And so
Torquemada thought that too, but
well, a lot of people think that, and sometimes they're right and sometimes they're wrong. But I would reject that analogy, certainly, that administrations are, torturers or evil kind of creatures. But anyway, so the other thing they're saying is that it shouldn't take effect in August because given all of the complexity involved in putting this into place, again, over 2,000 pages of regulations, and given all of the other things that institutions are dealing with right now, obviously, under this crisis situation, that this is going to be almost insurmountable burden. But of course, the administration, this has been underreported, I think, wants it in place now so it can't be potentially overturned by the Congressional Review Act, which allows any new regulation to be rejected by majorities, and that's no filibuster in both chambers within 60 legislative days. Now, the president can veto that, but if you have a Democrat in office and Democrats controlling both chambers, well, that's not an issue, and that's something that could certainly happen. So that's one of the reasons why this is kind of being pushed in right now, even though it might not be the ideal time to do it, given everything. That's an understatement, because they want to make sure that regulation is as hard to remove as possible. And that's something that, that's something that is not at all surprising. But
well, I'm again, I'm a little perplexed by that. If you think that Donald Trump would be concerned about a Democrat push to remove due process.
No, that's not. And
again,
see, you got to look outside your own frame on this, Jay. It's not a Democrat. Right. It's not a Democrat.
Who I'm saying who would object to this?
Almost everyone on the left. I mean, there's strong objections, and it's not.
Yes.
But again, I'm asking you to look at it outside of your frame. You're seeing it as due process, and that's a legitimate way to look at it. But the way most of us on the left see it as trying to redress issues, long-standing, not just generational, but millennia-long issues with victims and women's rights and abuse of women. And when you look at it in that frame, all of a sudden it doesn't seem like this perverse, awful, evil miscarriage of justice. It seems like an attempt to rebalance the scales. And I'm sensitive to that, and I understand where that's coming from. And I'm wondering if you can.
No, I can see it. I just think it's abhorrent. The idea that you would say, here is someone who may or may not be guilty, but they will lose their civil rights. We will assume that they are guilty because 1,000 years ago.
No, they won't lose their civil rights.
And you can explain to that kid's parents why he was kicked out of school and say, look, you got to understand, women have suffered a lot, and your kid may or may not have done this. And yes, he's going to be tarred for the rest of his life. He'll never get a job. He's going to be a public pariah, shamed on social media. People might protest your house. But you know what? Look, it's all in fairness here, and that's our view. I would say, okay, that can be your frame, but that's certainly not the frame that we see things through, and it's not our constitutional frame. It's not what historically has been. It doesn't comport with any idea of civil liberty.
Yeah.
So,
and see, I agree that there are some people on the left who would frame it that way, and that white males have it coming to them after generations, millennia of oppression. So you're absolutely right that there are some people kind of much further left than I who frame it that way. But I don't think, and obviously I know a lot of people at universities because that's where I've spent my career. That's not how we see it like that. We're not saying, well, let's stick it to whitey, let's stick it to males. It's a lot more nuanced than that. And I think part of the problem is that it's these extremist versions that get set up here, and you find one or two processes that are just way out of line, and that is set up as what everyone and everything is, and that just gets amplified through social media. And so I think that's a much more overly simplified way of looking at it than the actual reality of it.
Okay. I'll just close with, the U.S. Supreme Court has like in a million different times and a million different variations said that before someone can be deprived of a property right or a liberty right, they are entitled to due process, which is essentially a some sort of notice and a hearing. That you need to be able to have a notice of what you're being accused of and some sort of fair hearing to present your side of the story. And that's what has been lacking
in the legal system, right? But not in individual businesses. I'm pretty sure that's an important distinction.
Okay.
I mean, right? Because I mean,
I guess
businesses
the alternative. I mean, is colleges could do like what Hillsdale's college, I think, does, is say no, we won't take any government money, and then they can run whatever processes they'd like.
And now, of course, the Supreme Court has also ruled in a number of cases that federal financial coercion or the threat of taking it away can be so coercive that it is constitutionally impermissible. And so you could make an argument that would be the case with federal financial aid.
Okay. Well, let's see how that case turns out.
Yeah. Well, I'm just saying that
we are coercing them to allow the accused to submit evidence or to have cross-examination.
Well, and that's again, I would say that's a straw man. But anyway,
okay, if that's a straw man, what is the actual case then? What is the? I mean, because that's what the rule says. That's what the new stuff is in the rule.
Yeah, and the old guidance didn't say you can just basically put together some kind of kangaroo court, convince people, or and convict people without any evidence and so forth. So I don't
know. I agree. It's not a matter of convicting people without evidence, but it's a matter of allowing the accused to present his own evidence. It's really easy to convict someone when you've got all your evidence.
Yeah, and there are different processes in different institutions, and certainly some of them are better than others. But I would think that that especially people who are concerned about overreaching federal government would be concerned about the federal government just stepping in and saying, you will do it our one-size-fits-all way for everyone under all these conditions. And so I think there's just a little bit of inconsistency in that. But oftentimes that's what happens when somebody has a preferred outcome that they are arguing, based off of, as opposed to
what's the preferred outcome?
I think the preferred outcome is in this case that people feeling that, well, there should be one process that's exactly the same, not taking into account any individual circumstances and issues and that sort of thing. It'd be
what
like the
individual circumstances could be taken into account? I'm sorry, we're digging so deep on this, but this is interesting. And I'm what individual circumstances would change the right for the accused to submit evidence or to cross-examine, the right to a live hearing.
Well, I mean, I don't necessarily know. There could be instances in which a live hearing would not necessarily work out. I don't know what those would be necessarily because I can't envision all of the possibilities, all the contingencies certainly. But I know that individual institutions have thought about that in the context of their own situations, just like how individual states sometimes have different laws and regulations on things because they are the closest to their own situation and that of their own people, which is why, federalism, essentially. And again, I would point out that people who feel that they have been wronged by the system can always bring an action against the institution and can always bring actions against the person that they are alleging has, wronged them in any way, sexual or others. And I think that's an important distinction. So yeah. But, we're actually going to talk more about this in a way on the bonus show because, well, in addition to this, we're going to get into the Joe Biden Tara Reade thing a little bit, I think. We're also going to be talking about, my God, we went an entire show without directly talking about COVID stuff. I didn't think that was possible, but there's a lot to talk about there with states reopening. I'm going to kind of try to present it as sort of the trolley car problem from hell, basically. And it's an old philosophical argument, or if you're familiar with the show The Good Place, you're familiar with it as well. But that and some other stuff. So if you are a supporter, you'll get that and maybe a little bit more. And if you're not, well, hey, check out patreon.com/politicsguys. And if you can't afford to become a supporter, again, just email me, mike@politicsguys.com, and I would be happy to give you full access to that second full-length weekly episode that comes out every Wednesday. And that's really about it. So thanks so much. If you could subscribe to the show, we appreciate it. Leaving ratings and reviews is also helpful, as is this is a big one, sharing on social media or email. And you know how to get in touch with us more generally? mail@politicsguys.com. For more great discussions, please check out our Bipartisan Politics subreddit. We have the URL in the show notes, or you can just search for Bipartisan Politics on Reddit. We've also got a Facebook page where we post stuff. It's facebook.com/politicsguys page. And we are on Twitter @politicsguys. The executive producers of the Politics Guys are Bruce Johnson, Wilma Moreno, Andra Masker, Daniel Toe, and Chris Wilkerson. Today's show is produced by, us, Michael Baranowski and Jay Carson. We'll be back with a new show next week. We hope you'll join us.